we are three organizations today that are bringing in this presentation. I'm from the Massachusetts Law Reform Institute, which is a policy center that fights poverty, improves access to justice, and works to end the policies and programs that create racial disparities. My work is centered on one mission, which is for race not to be a predictor about how someone is going to fare in life. And so we welcome you today in furtherance of that goal. And I'm going to have Janine Solomon introduce herself.
Hi, good evening, everyone. I'm Janine Solomon. I'm a senior attorney at Mass Advocates for Children. And MAC's mission is to remove barriers to educational and life opportunities for children and youth. We advocate for and partner with students and families and transform school cultures to be safe and inclusive and supportive, create system change so that all children and youth can learn, reach their potential, and thrive. And as part of our direct advocacy, MAC maintains a helpline by which it provides information, resources, and referrals to youth parents and professionals. And that information will be made available in the presentations tonight and afterwards. Welcome and thank you. I'll turn it over now to Leon Smith and Erin Stewart from Citizens for Juvenile Justice.
Yes, good evening, everyone. It's a pleasure to be here with you tonight. My name is Leon Smith, and I am the Executive Director at Citizens for Juvenile Justice. We were founded in 1994 as the only independent statewide nonprofit organization working to reform and reimagine the juvenile justice and other youth-serving systems in Massachusetts. That includes addressing and dismantling the school-to-prison pipeline, whereby our young people find our educational futures disrupted by disproportionate school discipline and school-based arrest. It's a pleasure to be here with you tonight and a pleasure to be addressing this very important topic of race-based bullying. Erin?
Hi, everyone. My name is Erin Stewart. I'm a Skadden Fellow at Citizens for Juvenile Justice. I run the School to Prison Pipeline Project, where we focus on preventing and responding to school-based arrests, as well as school discipline disparities for youth. It's a pleasure to be here tonight.
Okay, so let's get started. We have a lot to cover today. And one of the main reasons why we created this series on racial bullying is because MAC was seeing an increase in their helpline regarding calls on racial bullying. And there was a report released in 2021 that said that students aged 12 to 18, 20% of those students experienced bullying. And out of those 20%, 1 out of 4 experienced bullying or harassment based on their race. Now, according to my children, that number is way too low. And we saw in Massachusetts an incredible increase in 2021, the 2021 to 22 school year. This is the number of complaints that the Department of Education, DESE, received. So our hope today is that to curtail or stop racial bullying, we can do that by equipping parents and caregivers with the knowledge they need to make sure that schools are doing what they're supposed to do when they receive a report on any racial incident or bullying. We believe that it makes it less likely that parents and caregivers and students will be taken advantage of. That makes it more likely that schools will be held accountable. And with those two things paired, we believe that then each school will have a better environment where racial bullying can no longer exist. So let me give you an overview of today. I'm gonna provide an overview of the process with Janine, sort of give you the big picture of what racial bullying laws and your remedies look like. Then Liza Hirsch from the Massachusetts Attorney General's Office will give us an explanation of state bullying laws. And then we're going to have a robust questions and answers. So I think we've allotted almost an hour, and we have representatives joining Liza for the question and answers. We have representatives from the U.S. Department of Justice and the U.S. Department of Education Office of Civil Rights. And then we'll have closing remarks and provide some resources. Again, you can ask any question in the chat, and we appreciate the questions that were submitted with registration. And we're talking about bullying today. This is the legal definition of bullying. As you can, bullying is a term that we commonly use to describe sort of any mean or insulting behavior, but between students or people. But there is a state legal definition, and it really requires repeated use of anything that creates or directed at a victim that causes physical or emotional harm or damage to property or creates a hostile environment. Liza will provide more detail about what that legal definition is, but I wanted to give you a broad view that is about a repeated use of someone who's being targeted. And as you can see in the definition, there's nothing here about race. But when you add race to the bullying, or if there's even a single incident, it is going to trigger other protections, other state and federal protections against harassment and discrimination based on race. So where bullying requires repeated harm, you could still seek protection from your school, from the government, even if there was a single incident. And to give you an overview, there's state and federal laws that protect, that relate to bullying. There's no federal definition for bullying, so there's no federal bullying statute, but there are protections for anything against harassment or discrimination, bias, or hate that is related to a protected ground like race or disability. And there are also specific state laws that Liza will talk about that relate specifically to bullying and racial harassment. And obviously some of them, like our civil rights, you will share both protection and state and federal. And so, this is a know your rights. So we wanted to make clear what your rights are. Students have the right to equal access to educational opportunities, to be free of racial discrimination and harassment, to have an environment that is conducive to learning, which means to have an environment where there are really no significant obstacles for you to be able to do as well as you can in school, that you should be free from retaliation. So if you make a report about bullying, you shouldn't receive retaliation from the school or other students. And that if you're a student who has a disability, that you'll receive support that is based on your disability behavior. And so another general thing is that what schools must do. So for you to understand that, every school has to have, and this is through state law, a written plan to prevent and stop bullying. They have to follow that plan. They have to provide clear process for you to report incidences, even anonymously. If you do report it anonymously, they can't take any disciplinary actions against the aggressor though, but you can report anything anonymously, and that they have to immediately investigate and respond appropriately to any reports of bullying or racial incidents. Again, you only need one racial incident to require the report. And then they also have to have language access. And I'm going to ask my colleague, Iris Coloma-Gaines, who's our state attorney on language access, to talk about your rights with language access.
Hi, everybody. Language access is required not just in the context of racial bullying, but in all situations regarding school for parents and families and guardians and students, so that they can receive notice and understand what their children are learning and everything that's going on in school. But with regard to And in order for schools to do that, annually, schools have to make inquiries into the home languages of all families that they are serving for the students, so that the school can be aware of any interpretation or translation needs that the families have. So for example, that sometimes comes in the form of a language preference survey at the beginning of the school year. So it's really important that parents and families pay attention to all of the papers that are coming home with their children or online from schools, asking all kinds of questions. And one of those forms will be a language preference form. And it's important that families fill that out so that schools are aware of what languages they need to serve and what languages this particular family needs. So with regard to bullying on an annual basis, the schools need to provide written notice of any student-related sections of the plan, the bullying and intervention plan, to students, parents, and guardians. And also they need to provide oral interpretation of the relevant student related sections of the plan if this student speaks language other than a prevalent language. So the school will have prevalent languages that they know that they serve based on what they get returned back on the language preference survey. And if the language is one of low incidence, meaning it's not one that a lot of families are speaking, those families still have a right and should request oral interpretation of the relevant sections of the plan, of the bullying and intervention plan. And if language access is not provided by schools within the context of racial bullying or within the context of anything with regard to the school, families can start complaints by going to the principal of that school. And if those things are not resolved, they can go to, in Massachusetts, the problem resolution system is part of DESE's, the Department of Education, and the Department of Elementary and Secondary Education. They can go to the link here to the problem resolution system, and folks in 9 languages can file a complaint online in one of those 9 languages and hopefully get help from the problem resolution system. So I will be staying throughout. So if there are any questions at the end during the discussion, I'm happy to answer those questions. Thank you.
Thank you so much, Iris. Nope, it's moving faster than I am. And so we wanted to provide a simple timeline, and this is when the school, so there is an incident, you report that incident or bullying to the school. There's no magic words. You can just describe what happened to that day. Please write it down. There's options often to call, and we say even if you had, if you saw a teacher in the schoolyard or bumped into the principal, we really recommend following that up with something in writing because we want to keep documentation of everything that has transpired, and you want to keep a copy of that. Once the school receives a report, they must promptly investigate that report, and then they determine whether that incident or bullying occurred. If they say it occurred, they have to create a disciplinary action and create for the aggressor, and then make sure there's a restoring of a sense of safety for the target. Parents and caregivers of both parties, the target and the aggressor or bully, need to be notified and told about the PRS, which Iris just alluded to. Oh, sorry, that Iris alluded to, about the PRS process. And if necessary, if the incident requires law enforcement, they should be called there. Also, parents should be made aware of. And then if you disagree or believe that the school, did not follow their own plan or did not follow the law, you can file a complaint and seek review. And so we're going to spend the bulk of our time, or my time here, looking at how to file a complaint and where that goes. Again, It's federal and state. And so we're going to look at government agencies. You always have the right to bring a private lawsuit in court. But today we are going to just talk about the federal and state government agencies that you can complain to. So within the federal government, you have the Department of Education, the Office of Civil Rights, and as I said, they'll be here for the Q&A. You have the Department of Justice, the Civil Rights Division, and then at the state, you have DESE's Problem Resolution Solution Office, and at the Mass Attorney General's, and we're going to hear from Liza there. And they all enforce our civil rights and in different ways. And so we're just going to kind of give a little overview of what they do and don't do and some time frame. So we're going to start with DESE, their problem resolution system, which is what every school needs to notify both parents and caregivers about. They check whether or review whether the state or the school followed their school plan, their own plan, and whether they follow the law. So as I said, the state has their own anti-bullying law in the books and some other rules around how they must handle any incidents regarding race or harassment. So they review the school's procedures in investigating and addressing the bullying complaints. What they don't do is investigate if bullying had occurred or not, or if to determine if an incident was racial discrimination or not. So they don't usually review that part of a school's decision. They look at whether they follow their plan and whether they follow the law. So this is just sort of how it works. You can complain to the PRS either over the phone or through their online system. They will contact you within 3 to 5 business days, and they may request additional information from you, from the school. They will, if they continue with your case, they're going to ask the school to do a local report to see how they respond to this incident. They will give you time to respond to the school's local report, and then they'll make a decision within 60 days about whether they believe the school followed its own policies and the law, or whether they did not. So again, it takes 60 days from the date you complain, you file a complaint, until you get a decision with DESE or PRS. So there's 4 possible solutions here. They're either going to say that the school followed their rules and they don't see any non-compliance. They'll say that issue is not within their jurisdiction. They don't have enough information to make a decision, or they'll say that the school didn't follow their own plan or the law, and then they will work with the school to make sure that they comply or do what they're supposed to be doing. And so these are the parts of the next steps, which is, correction and action, and making sure they're monitoring them, making sure that they're following their own policies and the law in a very clear, in very clear ways. And then we have the Children's Justice Unit with the Mass Attorney General's Office. We have Liza here who's going to present, so I won't take much time here, but they're the enforcement arm of our state, so they can bring people to court. It's a government agency, so they do not represent individuals or families. They represent our interests, our public interest in having these cases prosecuted, and they enforce state and federal bullying and civil rights laws. And then we have OCR, which is the Office of Civil Rights. That's part of the Department of Education. They enforce civil rights laws prohibiting racial harassment and protecting against equal access to educational opportunities. Here, so this wouldn't be covering by general bullying. They are going to focus on those kinds of incidents that relate to somebody's identity. And so they will not investigate, or typically won't investigate, a case if another agency is already investigating, but they do partner and work and communicate with other agencies. Again, there's a federal agency, so they don't do individual representation. And if they feel like a case needs further, if there's not compliance and the case needs to go further, they'll refer it to the Department of Justice to do the prosecution of that case. And there's 180 days. You have 180 days from the time that the incident happened to file a report. I'm sorry, I forgot to tell you, for DESE or PRS, you have 1 year. They only look back to 1 year, and at OCR, they only look back 180 days. So you want to make sure you get your complaint in a timely manner. For OCR, there are a number of schools that are currently under investigation for racial harassment. So you can see if your school is there. This was updated in December of 2022. And so these are the current Massachusetts elementary and secondary schools that are currently under investigation. Then we have the U.S. Attorney's Office. They have a civil rights division. They also enforce our federal civil rights laws. How they may be different from the Department of Education is that they don't prosecute every case. They have prosecutorial discretion to look at which cases they will take, and often choose cases when they see a pattern and practice of not following plans, or a pattern and practice of not following the law regarding protecting people from racial harassment and discrimination. I know we're going through it quickly. You're going to get these slides, so please don't worry. But this is just a sort of a little rundown of what to think about with these cases and these agencies when you're choosing which one. You don't, you can choose more than one. But to be clear, that PRS is not going to, again, look at the underlying decision about whether it was bullying or not. Our federal government, because bullying is not a federal definition, they're not going to be making a decision on whether it meets our state definition of bullying. And then the Mass Attorney General's Office, OCR, and the federal agencies are going to look at whether there was racial discrimination or harassment. And so where to file complaints, all of them allow you to file complaints online. The PRS and the Department of Ed also have email addresses and phone numbers that you can call as well. And so we have some tips. We want you to make sure you write everything down as soon as you know what happens. You want to keep these notes contemporaneous, which means as it's happening and as you learn about it. You want to create a timeline. I've always said this to all my clients, a timeline is the best thing, where you keep the date of something that happened. It helps you stay organized. And then you want to keep all school records and communications. So many schools allow you to file that complaint online. So make sure you can get a copy of that, whether it's even just taking a picture of your screen. If they don't give you a copy when you submit it, you just want to make sure you have any and all school records and communications about these incidences. And then just remember, there are places and people here to help you, and tons of resources. So our big takeaways are: no one should suffer from racial bias, discrimination, or harassment at school. Report every incident, every and all incident. Nothing is too small, nothing is insignificant. The harm is real, and so we want everyone to be reporting this. Schools should have a written plan. They should be publicizing that plan. People should know about it. They should deal immediately with any reports about racial incidences or racial bullying. And there are schools, federal and state laws to protect you. The resources, so we're going to give this out, but there's resources from the Mass Attorney General's Office with guidance about specific obligations about hate. We will put these also in the chat. There's a ton of resources from the Department of Education's Office of Civil Rights. I couldn't provide them all, but so I'm giving you a link to their website. At Mass Legal Services, we offer a library of resources. We've created a section on racial bullying. So you'll see a section of a library called Racial Bullying, and there will be a ton of resources there that are open to the public. And then I don't want to forget that if you want to speak to someone, if you have a case, Mass Advocates for Children runs, as Janine said, a helpline. There's also Massachusetts Legal Resource Finder, which helps you find free or legal aid in Massachusetts. And then Lawyers for Civil Rights, they also do direct representation for folks who are suffering from racial incidences or bullying. That is my time. We're not going to get to the Q&A right now. We're going to turn it over to Liza. So let me just stop sharing my screen.
Yeah, and just to remind people again, the portion that we just presented was recorded. That will be made available along with our slides and some slides from our presenters, as well as resources and an exit survey. And we'll be posting some of those materials in the chat throughout the evening, but we'll also make it available afterwards.
Absolutely. Thank you for that announcement, Janine. And thank you so much, Virginia, for the very thorough presentation. Now I will pivot to this evening's event's panel of experts on this issue of race-based bullying. And up first, exploring the Massachusetts State Bullying Statute, as well as the Massachusetts Student Anti-Discrimination Act, will be attorney Liza Hirsch. Attorney Hirsch is the director of the Children's Justice Unit at the Massachusetts Attorney General's Office. Prior to joining the Attorney General's office, she was a senior attorney at Massachusetts Advocates for Children, where she provided representation to parents and students in education matters and directed the program on disrupting the school-to-prison pipeline. She is a recipient of the 2011 Skadden Fellowship and a graduate of Northeastern University School of Law. Attorney Hirsch, I turn the floor over to you.
Thank you so much, Leon. And I apologize, I don't have my usual voice because I have a bit of a cold, but hopefully my voice will last throughout the rest of the evening. As Leon said, my name is Liza Hirsch. I'm the director of the Children's Justice Unit at the Massachusetts Attorney General's Office. And today I'm going to be speaking about state laws protecting students against bullying and harassment on the basis of race, as well as other protected classes. And I will also be going over the process of filing a complaint with the Civil Rights Division of our office. So with that, Virginia, would you mind just pulling up my slides? Great. So you can go ahead to the first slide, Virginia. So I want to start by emphasizing that there are two main state laws in Massachusetts which protect students against bullying and harassment. And these are the two laws: the Massachusetts Anti-Bullying Law and the Student Anti-Discrimination Act. And those are the citations to those laws. Next slide. This is something that Virginia went over, but I think it's worth re-emphasizing the definitions of bullying and harassment and the differences between the two. So bullying includes targeted and repeated behavior that causes harm toward another student. Bullying does not necessarily have to be bias related, but oftentimes it is. Harassment, on the other hand, is any conduct that contributes to the creation of an intimidating or hostile environment because of a student's protected characteristics. So the way that I think about it is that bullying has to be repeated and is targeted at an individual student. Harassment does not need to be repeated. It can be repeated, but it does not need to be. One incident, if severe enough, could constitute harassment. And harassment does not need to be targeted at an individual student. It could be the overall creation of a hostile environment on the basis of one or several incidents. And it does need to be on the basis of either race or another protected class. As many of you, I'm sure, know, bullying and harassment can take many forms. Some examples: verbal statements, graffiti, online or social media activity, and violent or threatening physical conduct. Next slide. So what are the school district's obligations? Virginia went over this, but again, I think it's worth re-emphasizing because the more we all hear what the process is, the easier it is to remember. So once a school district is on notice about an incident or series of incidents that may constitute bullying or harassment, the school must promptly investigate and respond to those incidents if bullying or harassment is found through the investigation. As Virginia noted, specific words are not necessary to prompt an investigation. I find that this is often an area of confusion. As a parent, you certainly can request a bullying investigation, for example, if you feel your child has been bullied. However, you don't need to use the word bullied or request a bullying investigation for the district to have an obligation to investigate. What prompts the obligation is the district being on notice that there are incidents that may constitute either bullying, harassment, or both. So just learning of the facts of a situation, the school district may be on notice and may be obligated to initiate that investigation. As a parent, you may want to request a bullying and harassment investigation because that may ensure that the district will do so. But it's important to know that those magic words, bullying, harassment, are not necessary to prompt an investigation. Incidents, it's important to remember that incidents may involve bullying or harassment or both bullying and harassment, and school districts must meet their obligations under both laws, the Massachusetts Student Anti-Discrimination Act and the Massachusetts Anti-Bullying Act. So the school district receives notice that there's been an incident or a series of incidents that may constitute bullying and or harassment. That triggers the school district's obligation to investigate. The school district conducts an investigation, which may involve interviewing witnesses, students, teachers, staff who are involved, and then we'll make a determination about whether bullying and or harassment occurred. Let's start with bullying. If a school district determines that bullying has occurred, that after they reviewed the facts, they determined that yes, these facts meet the definition of bullying, the legal definition of bullying, then the school district must take clear steps to restore the safety of the impacted student. Oftentimes, this takes like a safety plan is the way in which this requirement is implemented. The school district also must notify the parents of both students, both the impacted student and the responsible student, and then take appropriate disciplinary action. Similarly, if the school district concludes through its investigation that harassment has occurred, the school district must take appropriate disciplinary action. Next slide. Oh, can you go back, Virginia? Okay, so what constitutes an appropriate disciplinary response? It really depends on the situation. So there's not a one size fits all here. It's really important for disciplinary actions to balance the need for accountability with the need to teach students appropriate behavior. So on the one hand here, an inadequate disciplinary response can encourage bias-related misconduct and can contribute to the intimidating or hostile environment. On the other hand, we know that suspension and expulsion may not always be the most effective response for changing behavior and can also further racial and other inequities. So it really depends on the circumstances. Alternatives to suspension, which directly address the bias and harm, may be considered. But again, it's really a case-by-case basis, and it should really balance the need for accountability based on the circumstances and the importance of teaching students appropriate behavior. Next slide. As Virginia mentioned, school districts also have obligations, legal obligations, to prevent bias and hate. So here are some of those obligations. School districts must review the curricula to ensure that it's not discriminatory. Schools must teach students skills, knowledge, and strategies to prevent and respond to bullying and harassment. And schools must develop and implement plans to protect vulnerable students, implement policies and procedures for reporting, investigating, and responding to bullying and harassment, and then professional development, train administrators, teachers, and staff to implement those policies. Next slide. Okay, so now I'm going to go over the process of filing a complaint with our office, with the Massachusetts Attorney General's office and the Civil Rights Division. I direct the Children's Justice Unit, which is part of the Civil Rights Division. You may file a complaint if your child has experienced bullying and or harassment on the basis of race or ethnicity or any of these other protected characteristics. And we recommend filing in particular if you believe the school district has not met its legal obligations to investigate or has not responded appropriately or in compliance with the law. Next slide. So this is a link to our online complaint form. This is the civil rights complaint form. It is available right now in 3 languages, English, Spanish, and Portuguese. It's a very straightforward form that anyone can complete. You simply provide your name of the school district, and a clear summary, your name, contact information, name of the school district, and a clear summary of what happened. And our office will review the situation. In terms of when our office may get involved, we're more likely to get involved if it's an incident involving hate or bias, and if it's either an egregious incident, a series of incidents, or pattern of practice of a school district, systemic kind of failure to adequately address hate and bias by a school district. Those are the kinds of incidents that we are most likely to investigate. But with every complaint that we receive, we will respond. So we'll either send a letter, a referral letter, which provides additional resources and may provide other appropriate places to direct a complaint. For example, the problem resolution system at DESE, which Virginia mentioned. Or in some cases, again, if it falls into our parameters and our authority, our review can take a couple of different forms. We may contact the school district to try to resolve the matter more informally, and reach out to the family and have more of an informal back and forth to try to resolve the situation. And then in more rare circumstances, and this is really when there's been a really egregious violation or series of systemic violations, our office may open a full investigation, which would involve conducting interviews and gathering evidence. You can go to the next slide, Virginia. In terms of time frame, once a complaint is submitted online, a review takes usually between 1 and 4 weeks, sometimes a little bit longer. If we decide to open a full investigation, which again is fairly rare, but if we do open a full investigation, that investigation would take between 6 and 18 months. And then there are some instances in which, again, we may become involved more informally to help to resolve a matter if it is related to racism, protected class, or otherwise hate and bias related. Next slide. I think that might be the end. Actually, if you would go back 1, Virginia. So just to reiterate, a few factors that we consider when determining whether or not to become involved, either informally or more formally, is again, whether the incident involves hate and bias. Second, whether the incident is either egregious and or systemic in nature. Whether the school district has already conducted its own investigation. So that is important. If a school district hasn't yet conducted an investigation, we're not likely to become involved until the school district has done so. And we'd also be looking at the adequacy of the school district's response. We also consider whether PRS or OCR, problem resolution system at DESE, State Department of Ed, or the Office of Civil Rights, Federal Office of Civil Rights, whether either of those agencies is involved, because we make an effort not to duplicate investigations. And then finally, whether the family has an attorney. If a family does have an attorney, we're actually less likely to become involved because we know that families who have attorneys are more likely to be able to effectively enforce their rights. Whereas, and we receive so many complaints from families who don't have attorneys that we may be more likely to become involved in those instances. So I think that's the end of my presentation, and happy to answer any questions during question and answers.
Thank you so much. Thank you so much both to Attorney Benzon and Attorney Hirsch for such fantastic and informative presentations, really giving us a lay of the land here in Massachusetts. Now we're going to shift to our question and answer session. So the three organizations who organized this, really the ultimate purpose for tonight's event was to connect the community directly to experts at the federal and state level who can answer questions and provide guidance on these issues that are having such a significant impact on our young people. And I want to thank all of you all for submitting so many compelling questions in the chat. I've been watching as they've been coming in. So very quickly, I will just introduce our panel who will be responding to questions. Of course, you just heard from Attorney Hirsch, but we also have from the United States Department of Education, Office of Civil Rights, Attorney Tommy Noda. From the United States Attorney's Office for the District of Massachusetts, their Civil Rights Division, we have Attorney Tori Cummings. And from the United States Department of Justice, Civil Rights Division, we have Attorney Anuj Kaderpal and Attorney Hillary Harnett. So at this point, I wanted to thank you all again for being here, and I'll pass to my colleague, Erin Stewart, who will be sending questions to our panel.
Thanks, Leon. First of all, I just want to thank all of you for such great questions. This is an awesome list that we have so far. So our first question is, how do you report a school that has clearly dismissed reports of bullying and exhibited racial discrimination when asking for help? Liza, do you want to start with that one?
Yeah, Erin, would you repeat the second half of that question?
Yeah, sure. So how do we report a school that has clearly dismissed reports of bullying and exhibited racial discrimination when asking for help? Okay, so it really, again, it's going to depend on the facts of the circumstances. But in terms of not dismissing reports of bullying, that would be something that you may consider filing with PRS initially. If it's regarding an individual student that's been subjected to bullying, and if the district has not responded appropriately. If it's in a situation that involves race-based harassment and or bullying and is more systemic in nature, and it's clearly racially discriminatory, that also may be an appropriate time to file a civil rights complaint with our office. It's also possible to file both with PRS and with our office. However, our office is not likely to become involved if there's an open PRS matter. So our office is likely to wait until after PRS has concluded its review before getting involved. But in general, if it's more on the scale of kind of individual bullying situation and concerns about the district not following its own bullying prevention and intervention plan, that may be appropriate for PRS. If it's on the scale of, broader systemic failures to address racial harassment and bullying more broadly, or if it's a particularly egregious series of incidents or even a particularly egregious single incident that involves hate and
racism, it may be appropriate for our office.
Great. Thank you so much, Liza. That was a really thorough answer.
I'm sorry, I just wanted to break in. I'm going to stop the recording just to make sure that people feel comfortable asking their questions. So while I